Welcome, M. Solomon. I'm your accountant and auditor, specializing in mortgages, subprime mortgages, and foreclosure. 30 years secondary markets. I was a subservicer, an aggregator, and a warehouse line provider as CEO and CFO for Mortgage Guarantee out in Los Angeles. I have over $1 billion non-agency subprime loans bought and sold. We provide attorneys and their clients with accurate and concise data and facts to show conclusive evidence of an abandoned asset at time of foreclosure sale. You can reach me at email secondary trade desk, just as it sounds, also as it looks, secondarytradedesk@gmail.com, or call me if you have questions about our audits and how you'd like us to participate in your case if you're an attorney or if you're an individual filing a lawsuit or defending yourself pro per, pro se. You can reach me at area code 725, new number. We're transplanted or relocated from D.C. to beautiful Nevada, Las Vegas. 725-270-8632. 725-270-8632. Let's get started. Well, we've picked up another case, and we have a client out of the state of Massachusetts. And we're talking today about rigged mortgages using timing for valuation purposes. Rigged mortgages using timing for valuation purposes. Again, I'm not one big on conjecture. I like to let the facts speak for themselves. I will tell you that subprime non-agency loans were easy target. I could see that way back in the early 90s, mid 90s, and that was when the FICO scores were first coming in. They were a target for a population of consumer and borrower that had a high default rate, and that the cost of the subprime securitization was such that it was not really working, but there had to be something better, bigger and better, that could be done with that pool or that population of homeowners. Most of them, if not the majority of them, were stated income, stated asset. Many were not filing their taxes. They're non-tax filers, and that's the biggest population of American that would cure all of the United States economic woes if that population of people were to pay taxes. But anyway, I'm not going to guess at how the program was motivated or what motivated the program to actually get started, but you're talking about the subprime sector, and what we're talking about here is a strategy that set the date of default in advance of the loan's closing. The default is set in advance of your loan closing. You're walking into a signing with a default and foreclosure already scheduled, and that allows you to take the property in trust and convert the transfer into a 10-year bond or securities, which we call debentures. Remember, the cost of originating a loan would be an obligation or debt of the lender and seller to the creditor. In this case, it washes out into equity, and the equity is for bond debentures and other types of securities that would be acting as debt, but treated as equity, that are sold to the consumer in exchange for the cancellation of debt by involuntary conversion of that debt into income, and that income then gets credited back as rent. It allows a lender to take your property and over 10 years write off bad assets at as much as 10 or 11 to 1, even 12 to 1, write off bad assets. And it's important that you know it's a 10-year bond, and the number I just said, 12 to 1, I'm going to show you why that's so important. But what happens is when you take the mortgage up front, you're selling it back to the consumer as a seller. So the lender in this case has sold the loan to a creditor, and the creditor is taking title and giving it to, or transferring title into trust to a trustee in an indenture. The trustee, through a nominee, imagine that, MERS, a nominee is selling it back to you as your equity. It's called seller carryback financing, AITD, all-inclusive trust deed. So MERS is a seller incident to a debt. I got to tell you this, it's not a real really representing the lender, it's representing the seller, incident to a debt where the seller carries back the financing. And what happens is when they amortize or pay down that mortgage note that was canceled, when they pay that down to zero, say over 10 to 12 years, you pay it down to zero, the value is just that, zero. And at zero, there's nothing to foreclose on. In keeping with the law and excuse me, getting over a cold, keeping with law and the proper procedure, practices and procedure for accounting under GAAP, and I assume FASB and International FASB, abandonment is where the property is at zero and it's in the trustee's best benefit or interest to dump the property and abandon it. That's usually evident by your insurance saying, hey, your insurance policy has been canceled, and other quirks that will coincide with right around the time a foreclosure is brought. So abandonment is where property is either burdensome or offers inconsequential value and benefit to the bankruptcy estate. This is bankruptcy law, of course, where there's a trustee, and a trustee is authorized to abandon the property. Once property is abandoned, it is no longer property of the estate. That way they can't get in trouble for taking your home. Instead, the property reverts to the ownership by the debtor, and if you're crying fraud, you're not claiming back your property, and as a creditor who has the right of reversion, you blew it. Fraud repudiates all the creditor's claims. So what you're talking about here is a reversion right, which would be the right to reclaim your property, and quiet title. I'm not an attorney. Only an attorney can advise you of your rights and legal rights in property. I'm just telling you what we testified to as experts with our experience and our history of being involved in the subprime industry. Okay, that's a lot to digest, but try to just think it over and maybe look at this presentation a couple of times. It'll start sinking in. Trust me, it will. It'll start sinking in. All right, let's take a look at this. What we're talking about the Y2K legacy timing and valuation scheme. And here's your formula, folks. 12 months times 10 would be 120, correct? So 12 months times 10, 120. That actually is 12 months times 10, so it'd be 12 plus 120. Plus 12 months, plus 180.5, plus 26.5. What I left out here is the 7 days, which is the adjustment made by the Department of Treasury. But for the purpose of this presentation, I'm showing you what the legacy timing and valuation scheme is, which is 12 months, 10 years, 12 months, 180.5 and 26.5. This would be for aging, going in. That's for the conversion of an asset into securities. This would be a 10-year bond. This would be for the exit strategy, for the conversion of the securities back into title or abandonment of a worthless security, and the right to attack title where they don't, they've abandoned it. 180.5 I use for a 1031 like-kind exchanges, tax-deferred exchange, and 26.5 is just a tie-out that I've used in every case that we've evaluated. We discovered this many years ago, and we've been applying it to every case. We'll apply it to your case, and it shows that you are part, if it verifies, it shows that you're part of a controlled business arrangement. Let's take a look at how the numbers fall into play. We're going to use an actual file from a foreclosure taking place right now in the beautiful state of Massachusetts. So there's your closing. We'll allege this case closed on 3/16/06. That's when the borrower received funds and received a new loan. The prepaid interest was for the end of the month. That would be 16 days. Prepaid interest would be 4/1/06. And now we start with the timing scheme. We have 365 days, which would be 1 year, 12 months, and a 10-year bond. So that times 10 take us out to 331.17. Now add back 12 months, aging, exit strategy, 331.18. We adjust by 180 days, takes us to 9/27/18, and adjust 26.5 days to tie out the legacy scheme. Tie out 10/24/18. What does that mean? That means after I add or subtract 7, they cannot foreclose until after 10/31/18. So there you have it. Those are your number of days, and that's tied out at 7. Now let's take a look. A couple other things I want to add here first before we move on. Okay, the tie out, as I mentioned, this is called for by the Department of Treasury. And if you look at the language in the notice of default or the notice to intent to file foreclosure, it'll say usually that the document will require that the following dates that I'm giving you are included as in accordance with statute. Well, as you can see, this is a CBA, controlled business arrangement. This would have nothing to do in statute, nor could I find anything in statute saying that this kind of forecasting would be allowed. In other words, what's happening here is on this date the loan was originated, they already knew the foreclosure date. The foreclosure date was already set. So this was a default that had to happen. Why? Because the default is been substituted with something called disposition of an asset, when an asset's written down to 0. So they're substituting the disposition of commercial assets and securities filed under UCC 1 for a mortgage that would be recorded locally in the state. They're doing a switch and bait or substitute and delete. It's called conversion, and that's the reason for the two 365-day aging requirements in addition to the 10-year bond, then the 1031 exchange, and the adjustments here and there. So let's take a look at the actual file. Let's continue. So let's finish it up. Drum roll, please. No, I'm just kidding. Here is a part of the notice of intent to foreclosure notice from the attorney. And as you can see, it says right there, the loan was originated in Boston, Roxbury, Suffolk County. It was recorded locally on March 16, 2016. Obviously, I had to have that date to get this thing going. And it says the borrower is hereby notified in accordance with statute, our intention on or after October 30th, 2018 to foreclose. And that we came up with October 31st, 2018. I'll just make one correction to what I said previously, and that was the foreclosure could not happen until after October 30th, 2018, which means 10/31/2018. This case was now eligible for a foreclosure. But what you're seeing here are the results of the timing scheme. And this is what I mean by a faceless electronic means and methods used to foreclose. These computers are doing it for the lenders, the parties that were supposed to be lenders and the ones that are foreclosing. In some of my other videos, I go into the reasons why they're doing this, but this is obviously a loan that was originated under a scheme that as of this date it was entered, the foreclosure date was already set, and that would be no sooner than after 10/30/18 midnight, which would be 10/31/18, which is what we came up with. Here you can see the players, HSBC Bank, which is a national association. Interesting. It's now an American bank. Australian bank's now an American bank. Interesting. As trustee, that would be a creditor for ACE. ACE would be the securities issued under the Home Loan Equity Trust Series 2006. That would be the obligor, and it'd be for the asset-backed certificates and their investors. And guess what? Guess who the asset-backed investors, asset-backed pass-through trust certificate investors are? It's you. That's who you are. So anyway, thank you for joining me. I hope this helps enlighten you a little bit and show you what's going on. This is part of a rigged system and a faceless foreclosure means and methods used to take properties in advance of a scheduled default and foreclosure date. All right, take care.